before the court today is State of Ohio versus Christopher, is it pronounced Varouh?
Varouh, yes, Your Honor.
All right. Each side will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal. When you take the podium, please just let me know if you want to reserve time and how much. I'll do my best to track that for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. All right, we've read the briefs and we're ready to proceed.
May it please the court, I'm Jack Bradley, and I represent the appellant Christopher Varouh. I would ask the court to give me 3 minutes of rebuttal time.
Thank you.
In this particular case, Mr. Varouh was charged in the Oberlin Municipal Court with domestic violence, assault, and aggravated menacing. The case did proceed to a bench trial, and prior to the bench trial commencing, the state of Ohio had asked the judge to grant a continuance of the trial because the complaining witness had not appeared. There was a short recess taken, and then the court was informed by the prosecutor that the prosecutor decided to go forward and present the 2 witnesses that she had. One was a deputy sheriff who came to the scene of the incident, and the second was my client's ex-wife, who was called by the complaining witness, and so she also reported to the scene, and so she was called as a witness. During the trial, the state attempted to elicit statements made by the victim to both the sheriff's deputy and also to my client's ex-wife. Over objection, those statements were not permitted into evidence because the state had failed to provide a proper foundation for excited utterances to come into the trial. The state then rested their case, and I moved pursuant to Criminal Rule 29 for a dismissal of the charges, arguing that the state had not sustained its burden, even construing the evidence in a light most favorable to the state.
Can I ask you a question about that point? I may have misread something, but I thought I read something that said the state didn't actually rest, or was that just something the trial court said? I mean, there's no issue when we look at the record that the state rested.
The state said they had no further evidence to present, so
Okay, thank you.
I think at that point it was clear that the state had in fact rested their case.
Thank you.
The judge did not rule on the Rule 29 motion, but asked counsel for both sides to prepare briefs on the issue of the Rule 29. In the state's brief, the state basically conceded that it had not established the elements of domestic violence, and it had not established the elements of aggravated menacing. The state asked the judge to conduct a special hearing on the aggravated menacing charge to see if the court would make some type of ruling regarding the excited utterance issue. At that point, the trial court actually didn't deny the Rule 29, but permitted the state to reopen their case. And the court ruled that the state could recall my client's ex-wife, Kristen Knievel, and Deputy Strinka. And in the court's ruling, the court basically laid out an outline as to how to introduce excited utterances into evidence, which I believe was totally improper because the state had its chance to examine the witnesses. I had a chance to cross-examine the witness, and the state failed in its burden of proving its case beyond a reasonable doubt. So the court then said that the state was going to be allowed to call those 2 witnesses back to the stand, and excited utterances into evidence. Well, as it turned out, the complaining witness then did show up for the trial, and she got on the witness stand and basically indicated that she had lied and that she had not told the truth, that she felt that Mr. Varouh was cheating on her, that she was told by Mr. Varouh's ex-wife that this would help her in getting custody of her child, and that she had no place to live, and was afraid that she would be kicked out of the residence, and so Mr. Varouh, the best thing to do is to have him arrested. Then the other two witnesses were allowed to testify again, and again, the complaining witness had testified, so they were allowed to testify as to her excited utterances because the state was able to establish its foundation. Prior to the second trial commencing, which was several months after the first trial, I had asked the court to grant us a jury trial because I felt that the court had already telegraphed its opinion on this case by giving the prosecutor a primer on how to introduce excited utterances. And at that point, my client did not feel comfortable with the judge hearing the case and felt that he should have a jury trial. And since the case was basically getting retried all over again, with the addition of the complaining witness getting to testify, that my client should have had a jury trial. I also asked the judge to recuse himself. I did not file an affidavit of prejudice with the Supreme Court, but I did ask the judge to recuse himself. I can't say, honestly, that I felt that this was an issue that should have been addressed by the Ohio Supreme Court. I just felt that it was something that, based upon the judge's ruling on the Rule 29, that he might feel more comfortable having another judge listening to the evidence if there was going to be all the evidence reintroduced with the complaining witness and these excited utterances coming in to court. So the judge made his ruling. He found Mr. Varouh guilty on all three counts and sentenced him accordingly. He was granted a suspended sentence, fines, and community control, basically. But even after all the two trials, we do not believe that the state has established even venue in this particular case. I know there was an address that was given, but it was never indicated what city that particular address is associated with and whether or not it was properly established that there was venue. I think it's very clear that there's a purpose for Rule 29. And I understand that courts have on occasion, prior to ruling on the Rule 29, allowed the state to reopen their case for limited purposes, such as if the state made a mistake and forgot to establish venue. And the state said, hey, Judge, could we reopen our case because we want to establish venue? But in this particular case, it wasn't just a simple error that was made by the state. It was the fact that the state was unable to establish a foundation to admit what the state felt was critical evidence. And I think it's very key that the state admitted in its response to my brief for the Rule 29 that they had not established their case beyond, even in the light most favorable to the state, that there was a domestic violence or an aggravated menacing. So it's my belief that the judge abused his discretion in this particular case, that the judge should have ruled on the Rule 29. The judge said, well, he felt that the prosecutor was inexperienced. And based upon that inexperience, that somehow justifies letting the prosecutor reopen the case after the prosecutor learns how to introduce an excited utterance. The Crawford case by the United States Supreme Court made it very clear that a criminal accused has a right to confront the accuser. And there's been limited exceptions made, especially in the area of like domestic violence, where if the accuser is making these statements spontaneously and that they become something of an excited utterance and it's not for a further investigation of the case, that those statements can be brought in if a proper foundation is laid. But that foundation is very important. And I made it very clear to the court before the trial started that I thought that this case was going to involve Crawford issues because of the fact that the complaining witness was not available. So it wasn't like I tried to do a sneak attack on the state of Ohio and not alert them to the fact that they may have a problem getting in statements of the accused who had not appeared for the trial.
Counsel, was it also, because there's some flavor of that argument about what they had failed to establish was family or household member? What was the reasoning for, or was it just giving in the extended utterance?
The state had conceded in their Rule 29 reply brief that they had not established family or household member. I can't say if I agree or disagree with that, but that's what they conceded in their Rule 29 reply brief, so I'm not going to argue with that, but I think that they had failed to prove the elements of the offense based upon the fact that they were not able to. I mean, the judge, even in his Rule 29 or his ruling that we were going to be continuing the trial, said that the state had failed to prove that my client was the person who had caused the injuries to the complaining witness. And he said that on the first page of his ruling.
Was there something on the record to indicate why there needed to be briefing on a Rule 29? Any reason?
No, Your Honor. It was not requested by myself. I don't believe it was requested by the state of Ohio. The judge had taken a recess and then came back out and said he wanted briefs on the Rule 29. I think it's obvious that the reason that he wanted briefs was to give the state of Ohio an opportunity to possibly request that they be allowed to reopen their case. The state did not particularly or specifically ask to reopen their case. They asked for a special hearing on whether or not the court would make a determination as to admissibility of excited utterances.
You're in your rebuttal time.
So, in any event, I'll save a little bit for rebuttal. Thank you very much, Your Honor.
May it please the court, my name is Varouh and I represent the state of Ohio. The convictions in this case should be upheld. This case involves a serious allegation of violence against a family or household member. It also involves a victim who failed to appear initially for the trial for unknown reasons. Because of that failure, it was difficult for the state to initially elicit the testimony necessary to prove the charges. The trial court decided not to decide the case on that technicality, but to allow the true evidence to come in order to decide this case.
Counsel, it's not exactly just a technicality, is it?
Well, it is. When you're looking at the case law and determining whether or not to allow the state to reopen its case, where it's clear that the state has evidence that it can present to overcome the criminal rule 29 motion, it is proper to allow the state to reopen this case. Here you have two witnesses who appeared, the victim failed to appear. The state is asking questions about bruises that these witnesses have observed on the victim. And they are attempting to testify to the fact that the victim told them how she got the bruises. Due to the failure of the state to lay the proper foundation and ask the proper questions, the objections to those statements from the witnesses were sustained. And that evidence, which was right on the cusp of coming in, was not able to be allowed into evidence. The objections were properly sustained at the time, but from the way the initial portion of the trial went, it was clear that the state, if given the opportunity, could overcome the defects in the testimony in order to establish its case.
Let me ask you a question. You began your argument talking about the serious nature of this case, and I only know what I read in the briefs, but based upon that, I'd agree with you. Where do you draw the line on when the state gets a do-over? Because that's what this was a do-over. Did they get it on a traffic case? Where do you draw the line?
Well, I think you draw the line at whether or not the state is able to present evidence that meets its burden. I think a trial judge has broad discretion in determining whether or not to allow the state to reopen its case. It also has broad discretion in allowing the presentation of evidence in order to ascertain the truth. Trials are not sporting events, as the case law states. The fact that the prosecutor in this case did not ask the right questions should not allow a person to walk free from a criminal charge that they've actually committed. And so reopening the case is not going to allow evidence to appear that just simply is not there. When the case was reopened, the same witnesses came in and testified once the proper foundation was laid to all of the statements that the victim made to them, establishing that the defendant caused these injuries that they observed on that date to her. And so the state was able to cure the defect and overcome the criminal rule 29 motion, which is proper. And I would say that it's proper in every case. If the evidence was not there, then the state would not be able to prevail once the state's case was reopened. As for the issue of venue, the state was able to properly establish venue. Venue can be established by circumstantial evidence. There is case law that supports where you have evidence of the law enforcement agency that came to investigate the incident and where you have the address of where the incident took place, you are able to determine venue. In this case, you have a Lorain County Sheriff's deputy who reported to the scene, and then you have the physical address of the home where this incident occurred. It was 48130 Rice Road. Well, a view of a map in Lorain County will clearly show that Rice Road is solely located within the jurisdiction of the Oberlin Municipal Court. So with that, the state was able to prove its venue.
Didn't the trial court, in any of its entries or on the record, indicate that venue had been established?
The trial court did not state in any of its entries or on the record that venue was even an issue. And that's probably because, as pretty commonly known in this jurisdiction, the Oberlin Municipal Court judge has a uncanny command of his jurisdiction. He pretty much knows every street and road in the jurisdiction.
Even if that's true, and I'm not saying it's conclusively relevant to establish, but there's just nothing in the record, I'm guessing, about venue. A finding or an argument by anyone, is that correct?
That's correct. There is no statement by the judge that venue was established, and there's no statement by the judge that venue was an issue to be established, and there was no argument made on the record.
So when it's not an element of the crime charge, and venue, just assume for the moment, venue is not anywhere in the record, what is this court to do with that on appeal?
Well, first I would argue that venue is, the specific statement of whether venue was established is not in the record, but circumstantial evidence is in the record from which you can establish venue. And circumstantial evidence is just as strong as direct evidence.
The first time, the Court of Appeals is establishing venue the first time, right? Because there's nothing in the trial court record establishing it.
I would not agree with that.
Was the map to which you referred that would establish that Rice Road is only within the jurisdiction of Oberlin Municipal Court, is that in the record?
That is not in the record. It is not.
So if that same address exists in Wayne County, say in Orville, and it was never established it was in Lorain County and not Wayne County, would that be a problem?
It would not, because we have a Lorain County sheriff who was dispatched to that address, and that sheriff would have no jurisdiction in Lorain County. So you have a Lorain County sheriff, you have an address in Lorain County, Rice Road in Lorain County is only in this court's, in Oberlin Municipal Court's jurisdiction. So the state argues that by circumstantial evidence that established venue, even without the map. Those two issues, as the court has indicated through its questioning, are dispositive in this case. If the state gets unreasonable or unfavorable, decision of either of those, then we don't get to the facts that come in during the second portion of the trial. The state submits that venue was established and that the court did not abuse its discretion in reopening, allowing the state to reopen its case. With that being said, during the second portion of the trial, and there was but one trial that was held in two parts, sufficient evidence came into the record to establish each and every charge in the case. You have three witnesses, the victim herself who appeared during the second portion of the trial, Deputy Strinka and Kristen Knable, the defendant's ex-wife, who all testified to the victim having bruises. There were photographs that were admitted into evidence that corroborate those witnesses' testimony that the victim had bruises. Then you have statements from all three witnesses, that the defendant caused the bruises to the victim. You have Deputy Strinka, who testified after a proper foundation was laid for an excited utterance that the victim told him that the defendant had slapped her, had pushed her into a kitchen cabinet, had grabbed her and choked her. He testified to seeing marks around her neck, a bruise on her left bicep, a bruise on her cheek, and a bruise on her temple, all of which corroborated his testimony as to the bruises he observed. The victim also confirmed that she had many of those bruises and even had pointed out additional bruises to the deputy when speaking to him when he was dispatched to the location. She confirmed in her testimony, although she was recanting the basis for those bruises, that she had those bruises on her and that the defendant had caused them. And then you have Kristen Knable, who testified that the victim called her 2 times during the incident, that she was upset and distraught and afraid. And she testified to the defendant being high on cocaine, they had been beating her up all day, that he put a gun to her head, that he had, again, choked, slapped, and grabbed her. So you have the evidence that then comes in to establish what the state was not able to establish in the first portion of the trial, that the defendant here actually caused the bruises to the victim and that he assaulted her. Those facts establish the assault charge, and then the additional evidence of the fact that the defendant was the victim's boyfriend and that they lived together for a period of time established the family or household member prong of the domestic violence charge. With all of those facts, the state was able to overcome the Criminal Rule 29 motion and establish sufficient facts to support the conviction. As for the aggravated menacing charge, you have the testimony of Kristen Knable, who again testified that the victim told her that the defendant put a gun to her head, cocked it, and told her, "You don't bring a knife to a gunfight. That is a threat." The victim, Kristen Knable testified to the victim telling her that she was afraid for her life, that she was afraid to call the police because she thought that the defendant was going to kill her, and that she was hiding in the bathroom with the defendant and Kristen Knable's daughter. All of those establish the aggravated menacing charge. Clearly, a gun can cause serious physical harm to an individual. So the facts are there. Once we're gotten to the second portion of the trial to support all of the charges. Now, as for whether or not the state was able to establish a foundation for excited utterance, the appellant even admitted that during the second portion of the trial, the state was able to lay a proper foundation for excited utterance. You have the deputy and Kristen Knable testifying to the fact that the victim was distraught, that she appeared afraid, that when she was talking to Kristen Knable on the phone, she was loud and excited in her words and in her voice, that her voice was shaking. All of those things established that she was experiencing a startling or exciting occurrence. The statements were made to Kristen Knable during the stress of that actual occurrence because it was occurring as she was talking to her on the phone and the victim was trying to elicit some kind of help. Although there's no per se time span from the occurrence of the startling event and when the statements are made, you have the testimony of Kristen Knable saying she's talking to the victim on the phone at around 6:30 p.m. And then you have the incident report which indicates that the deputy was dispatched to the location at around that same time. So it's almost instantaneous, and there's really not a long period of time that transpired there. And then you have the victim who made the statements to these individuals. She has first-hand knowledge of what happened to her, and all of her statements are about the physical altercation and the defendant assaulting her. Those are the 4 prongs of the excited utterance exception to the hearsay rule, and the state was able to establish those. Then you also have the issue of whether or not the state was able to authenticate the photos. You have the Deputy Strinka who testified to the fact that he observed bruises on the victim, that his sergeant took pictures of those bruises, and then in court on the stand, the deputy corroborated his testimony with what was observed in the photographs and testifying that those were the bruises that he saw on the victim on the date and the time of the incident. The trial court found that there was a proper foundation laid and that the photos were authenticated and they were allowed into evidence. All of these things established the assault and the domestic violence charges. And then,
When were those pictures allowed into evidence? When were they proffered by the state for admission?
they were proffered by the state for admission in the first portion of the trial, and they were admitted into evidence at that time. Each of the witnesses testified to what was observed and what was displayed in those photographs, and they all acknowledged through the course of the trial that those were the bruises that the victim had on that date. Even the victim testified to that. Now, as for whether or not the facts support the conviction, they're not, whether a conviction is against the manifest weight of the evidence is an exceptional remedy. It is not used in every case. I submit to you that this is not the exceptional case where this is a proper remedy. In looking at all of the evidence and looking at the credibility of the witnesses and weighing the evidence and in giving deference to the determinations by the trier of fact who got to observe the witnesses, observe their demeanor, and the determinations that the trier of fact made on the excited utterance question and the authentication of photos, there is sufficient evidence here to support the conviction. There's more than enough evidence here to support the convictions. Because a trier of fact,
You landed perfectly on that last sentence. Thank you.
thank you.
Brad, you have 2 minutes and 11 seconds.
I think there's a reason that we have rules of procedure and rules of evidence, and that is to give both sides a fair trial. And when we start making exceptions to our rules of evidence, when we start making exceptions to our rules of procedure, we start going down a slippery slope. And the rules of evidence are very clear. If you have an excited utterance, establish your proper foundation, and then the evidence comes in during the trial. If If you fail to do that, it doesn't come in because you haven't done your homework and you haven't got it in properly. We have a Rule 29. It says that when the state rests, the court cannot defer judgment on that Rule 29. It must make a ruling before the case proceeds. I would have been much better off if I just rested. In other words, what we're doing here is we're saying that the Rule 29 doesn't have any meaning because the court, in its discretion, can always allow the state to reopen its case if it failed utterly in proving its case beyond a reasonable doubt. So, when I went home and I got the ruling from the judge on my Rule 29, I said, why did I even follow Rule 29? Because I guess it doesn't have any meaning. So I'm asking this court to enforce the rules of evidence and the rules of procedure and find that this case should have been decided by the trial court at the time I made the Rule 29 motion and not allowing the state to be schooled on how to get an excited utterance in and then reopening the case. Thank you very much.
Real quick, did you make another Rule 29 motion at the second
Yes,
closing
yes,
of
I
the
did.
case?
Yes, I did.
And the court ruled on that, or?
And yes, it denied it at that point. But one thing I want to say too is, as far as the facts are concerned, my client's ex-wife received a call from the complaining witness saying that my client was beating her up and threatening her and so forth.
I'm sorry.
Okay, thank you very much.
All right, thank both of you for your arguments. The court will take the matter under advisement and will issue a written decision that will be mailed to both sides as well as posted on our website, and that